What's important to note is we are waiting for a lot of discovery just on this very issue. Remember, this is a Fry hearing, so this is novel information. They call it science. We're disputing that. So we're looking forward to getting things that we are entitled to in order to prepare and conduct this Fry hearing. So we've been on this for a year and a half. Astrea on the West Coast has been on this well before that, and we're still waiting for significant portions of discovery that we're entitled to before we even get to the hearing. So that's why we made that demand. The prosecutor today responded in a letter form saying we're going to give you much of what you asked for that you haven't received yet. So we'll sit back and wait for those items. And just to give you what the prosecutor indicated to us in terms of the magnitude, I think they said that they were downloading this onto some hard drive that costs roughly $1,100, $1,200, and they've been doing this for probably 7 or 8 days. Not the DA's office, but Astrea on the West Coast, 24/7 with these high-powered computers, and they're only at 40%. So the other 60%, maybe it will come in another week or so. That's roughly 2 weeks of constant download. And then they have to give that to us, and then our experts have the right to prepare, and we can consult with them, and at some point in the future, hopefully we can go forward with the Fry hearing. The other issue is we also made a motion to sever or separate certain counts in the indictment. The prosecutor today submitted their opposition in regards to our motion. We've asked the court to have the opportunity to reply to their opposition, and he gave us until March 12th, and hopefully by then we can have a reply in. I'll leave it at that, and I'll take any questions. Well, did you have an opportunity to look at the motion? You may not. You have? Sure. You know, you have different victims and different evidence. And conceitedly, some of the evidence and some of the victims should be tried together, and we've conceded that in the motion. Many of the other victims should not be tried together. They have nothing to do with each other in the sense of the location of where the bodies were found, the type of murder that was committed, the evidence that they have. But in essence, what the prosecutor is doing is they throw everything into the grand jury, and they try to throw as much into it and then bring it before a jury, because there's the old adage, when there's smoke, there's fire. And that's something, obviously, as a defense attorney, we have to fight. But they have no business, meaning some of those counts, to be tried at the same time. Because at the end of the day, he's presumed innocent on each and every count, and he has an absolute right to have a jury consider the evidence as to those counts. So it would prejudice the jury if they heard other evidence that's unrelated. So that's why we make the motion to sever.